I didn't want to do another one of these videos, but I got about 30 seconds into Legal Eagle's most recent video on the quid pro quo Trump administration impeachment ordeal.
Taylor was asked to testify as a witness to the investigation into the Trump administration's efforts to pressure Ukrainian president, as well into the company Burisma for the purpose of eliciting or fabricating dirt on Hunter Biden. Fabricating.
The bias is strong with you.
Viva Frei, welcome to the vlog, and welcome to the vlog dog. Barney, look over here. There you go. Majestic and beautiful. Mwah. Down you go. Huh. Oh, oi. Okay, look, I didn't want to do another video pointing out Legal Eagle's apparent bias in his legal analyses of situations that are, at their core, somewhat political. But when I heard him ever so subtly insert the word fabricating evidence as relates to the allegations of quid pro quo, which are themselves serving as the basis for impeachment hearings of President Donald Trump, I knew I had to make another video. If you haven't seen my previous video calling out Legal Eagle on what I believe to be his bias in interpreting these types of situations, I'll link it right up here. And I am totally aware and very much sensitive to the fact that in making these videos, I open myself up to attacks and criticism for bias. It's normal, it's to be expected, it's actually fair game for what I'm doing. And I'm so much aware of this that I oftentimes overcompensate for any semblance of bias that people might accuse me of. So unless you have been living under a political rock, and if you have, can you please invite me in, you are all probably aware of the fact that the House recently approved a resolution to formalize the procedures for an impeachment inquiry. This entire impeachment process thingy is tremendously confusing. I have trouble understanding it myself, but from what I understand, the House approved a resolution not for impeachment itself, but a resolution which formalized the procedure for the impeachment inquiry, the results of which may in fact lead to a formal impeachment. In the context of this whole political, do we call it a circus or a drama? Either one, take your pick. But in the context of this entire political situation, Bill Taylor, a top US diplomat to the Ukraine, testified behind closed doors as to his now infamous text thread with Gordon Sondland, who himself is the United States ambassador to the European Union. But we may have to back up and give a 30-second summary from the beginning. I don't think I can do this in one breath, but let me give it a try. Recently, there was a leak to the effect that Donald Trump was putting pressure on the president of the Ukraine to dig up dirt on Hunter Biden, Joe Biden's son. In order to exert that pressure, Donald Trump was withholding $400 million in aid from the Ukraine, only to release that money if and when the Ukraine confirmed that it would look into Burisma Holdings and Hunter Biden's role in that company. Okay, that's pretty good, actually. There were allegations of impeachable quid pro quo of flying, and then there was a bombshell of a text exchange or a WhatsApp exchange between Bill Taylor and Gary Sondland to the effect that Bill Taylor says, as discussed, I think it's crazy to withhold security assistance from the Ukraine for purely political or campaign reasons. And some people have taken that text to be the smoking gun of the impeachable quid pro quo, notwithstanding Gary Sondland's answer some 5 hours later to the effect that no, you've misunderstood, there's no quid pro quo, etc., etc. We're gonna get into it. Bill Taylor recently testified for something like over 10 hours behind closed doors as to this entire situation. Notwithstanding the fact that the testimony was behind closed doors and nobody knows the tenor of the testimony except those who heard it, Bill Taylor's opening statement was obtained by the press. And in this context, I honestly don't know if obtained means leaked to the press. It sounds like it is in fact a selective leak, given the fact that the testimony was behind closed doors and the bulk of the testimony is still behind closed doors, with the exception of his opening statement. And this opening statement basically serves as the basis for Legal Eagle's most recent video on quid pro quo. What is quid pro quo? And is there in fact an impeachable quid pro quo in the current situation? And I watched his video thoroughly, intensely, multiple times, so you got a lot of watch time out of me, Legal Eagle. And as I watched it, I noticed certain elements of bias that I knew I was not going to be able to ignore and would have to address by way of this video. Let's start with the first one.
Seen defenders of this administration go from there was absolutely no quid pro quo to it would only be a quid pro quo if President Trump were really thuggish about it, to quid pro quos happen all the time, and in fact, they're actually really good.
All right, you see, this is a perfect mixture between confirmation bias and political bias, and I'm coining a new term. It's called political confirmation bias. Legal Eagle is appealing to what he perceives to be inconsistencies in the Trump administration's explanation for what happened and how it has evolved over time. And the obvious suggestion here is that the Trump administration lacks credibility because their explanation has shifted over time. Legal Eagle here is just pointing out the classic moving political goalpost. I didn't do it. If I did do it, you can't prove it. If you can't prove it, I did it, but there was nothing wrong with it because I was allowed to do it. And he's not necessarily wrong, but this is one one of those situations where the political bias would manifest itself as a criticism regardless of which line the administration took. If there are diverging opinions from diverging members of the administration, look, they're changing their story, it's a sign of guilt. If all of the members of the administration are saying the same thing, look, they're just pulling party line, it's a sign of guilt. The reality is, I'm not sure who forms part of Trump's administration in a technical sense. I'm not sure that Lindsey Graham forms part of the Trump administration. And incidentally, if you didn't hear Lindsey Graham's alleged explanation as to why it did not constitute a quid pro quo because it wasn't sufficiently thuggish, look it up. I had to double check to make sure that Lindsey Graham in fact said this. I found it cited in a number of other articles, but I didn't actually hear Lindsey Graham say it himself. That said, I haven't seen Lindsey Graham deny the quote that is attributed to him, and it's kind of not necessarily the best explanation as to why something does not constitute a quid pro quo. The idea that these varying statements from different members of the government is somehow a confirmation of an impeachable quid pro quo is itself something of a political interpretation. It's not a fact. Different people have different opinions and they say different things, and ultimately nothing's going to change the transcript or the summary of the phone conversation, which everybody has read by now. Which is why I genuinely believe that all of this discussion as to whether or not it is an impeachable quid pro quo is a question of opinion that people have already formed. People are looking at the same document coming to diverging opinions. It is a matter of opinion, it is a matter of politics, it is the political Rorschach test that I described in previous videos. And now let's move on to the second item.
Taylor's full testimony is currently unknown, but news agencies got a hold of Taylor's opening statement.
Alright, so nobody knows what Taylor testified in substance, but they somehow got a hold of his opening statement from which they are going to draw all of the conclusions they want.
Taylor famously texted on September 9th, "As I said on the phone, I think it's crazy to withhold security assistance for help with a political campaign." To which Gordon Sondland replied 5 hours later.
5 hours later.
Emphasis.
It took a whopping 5 hours for Gary Sondland to finally respond to Bill Taylor's smoking gun of a text confirming the quid pro quo. Incidentally, in my video where I broke down and analyzed in detail the transcript, I'll link that video right here, the same red flags went off in my head as well, and it was only people in the comment section who brought to my attention that the 5 hours in between Bill Taylor's smoking gun of a quid pro quo text and Gary Sondland's response was from midnight to 5 in the morning, at the very least from what we see on the texts themselves. There may be some discussion about time zones, but all that we know at the very least from the texts themselves is that this 5-hour window, which so many people find suspicious, myself included, is the 5 hours from after midnight to 5 in the morning when typically people are sleeping. And in full fairness, and to avoid any bias, I have seen a lot of people say that there was some evidence adduced that in that 5-hour window, Gary Sondland sought the advice of Donald Trump or other people prior to responding. I have seen people say that, but I have not seen any evidence to that effect. But all that to say that this 5-hour window, which Legal Eagle emphasizes with incredulity, that's not the right word. Whatever, that Legal Eagle emphasizes was 5 hours between after midnight and 5 in the morning. Incidentally, it does also make me ask why Bill Taylor would have been sending text messages at 12:47 at night. But let's get into that text message.
"As I said on the phone, I think it's crazy to withhold security assistance for help with a political campaign."
Alright, Legal Eagle is a lawyer, I am a lawyer. Any lawyer is going to tell you that when you receive a text, email, letter, any written correspondence that starts with "as discussed," very rarely is what follows actually "as discussed." Prefacing any written correspondence with "as discussed" serves exactly one of two functions. One, cover your two, set up. And lawyers do it all the time for a reason. When lawyers are writing opposing counsel, typically it's a setup. As discussed, you will do X, Y, and Z. And then the response has to be, no, that wasn't as discussed. Here are the nuances, etc., etc. It's among the oldest and dirtiest tricks in the book. When a lawyer writes to opposing counsel saying "as discussed," very rarely is it in fact as discussed, and more often than not, it has some sort of self-serving purpose to it. As discussed, you agreed to pay my client everything they're asking for, including legal fees, with interest, plus an admission of guilt. Now, admittedly, this is something of a straw man argument. It's usually a lot more subtle than that. If there's been a settlement in a file, you'll have things like "as discussed." There's a settlement in the file which will include interest, but the parties may not have in fact discussed interest. And by drafting it as discussed, it puts the onus on the receiving lawyer, who then has to come back and correct it. No, it's not as discussed. We did agree on the quantum, but we did not discuss interest. Flip side, when the "as discussed" written correspondence is addressed to, say, your client, typically it is a cover your butt correspondence. You want to make clear in writing what was discussed with your client so they can't come back to you in a year and say, "Why did you do that?" It may have certain commonalities in that that it's not necessarily going to be a setup, but rather it is going to be self-serving and make sure to protect you in the long run if you ever have to invoke that written correspondence. But it nonetheless has the same element of self-interest. Now, looking at Bill Taylor's as discussed, it could be one of two things. It could be a setup or it could be a cover your butt. It could be a throw someone else under the bus text. And then Gary Solomon comes back and corrects it with his "no, you've got it wrong."
Bill, I believe you are incorrect about President Trump's intentions. The president has been crystal clear, no quid pro quos of any kind.
Which itself could be a cover your butt text. The bottom line is that this entire text thread can tell the story that either political party wants it to tell. It's the political Rorschach test, and using it to support one theory over the other probably is going to be affected by the internal bias of that person. Although admittedly some interpretations are going to be more tenable than others. But the bottom line, whenever I see a written correspondence starting off with "as discussed," it raises red flags. If you in fact discussed it, why do you feel the need to put it in a written correspondence? And if it wasn't in fact as discussed, why are you putting it in a written correspondence?
This testimony paints a picture of the Trump administration's motivations.
This testimony paints a picture of the Trump administration's motivations. This testimony is not testimony. It is the leaked or otherwise obtained introductory statement. The 10.5 hours of testimony is still behind closed doors. And that I found to be the most subtle but the most insidious bias in Legal Eagle's analysis. Legal Eagle has taken the introductory statement of Bill Taylor's testimony and basically refers to it as his testimony throughout the rest of the video, where in fact the 10+ hours of his testimony is still behind closed doors. And I don't think that that does the breakdown justice.
Pun intended.
The bottom line is that Taylor testified that, one, there was in fact a quid pro quo. The White House conditioned the release of $400 million of military aid on Ukraine's statement that they were opening investigation into Burisma.
All right, I got a big problem with this. That was not Bill Taylor's testimony because we don't know what Bill Taylor's testimony was. We know that that was in the opening statement that was obtained by the media, but we don't know what Bill Taylor's testimony actually was. There was 10.5 hours of it. And it has to be clarified that an opening statement is basically like an opening statement in law. It is an unchallenged statement prepared by the witness. Unless I'm mistaken, we don't actually know what Bill Taylor's testimony was on that opening statement when cross-examined by certain members of the government. And I understand that there is the need to and the limitation of reporting on things with the facts as they currently stand. But I think it's misleading to refer to Bill Taylor's opening statement as testimony that confirms a quid pro quo. And I think one of the most important elements to all of this, especially as relates to the allegations of a quid pro quo, is whether or not the funds were in fact released in the absence of the undertaking that is the quo to the quid pro quo. If the funds were in fact released to the Ukraine in September as they were, in the absence of the Ukraine actually confirming that they were reopening an investigation into Burisma or Hunter Biden, that would very much undermine the alleged quid pro quo that Bill Taylor allegedly confirmed in his testimony. That to me seems to be the most critical fact in determining whether or not there was in fact a quid pro quo, setting aside whether or not it's an impeachable quid pro quo. The quid pro quo as described by Legal Eagle, summarized from Bill Taylor's testimony, which is in fact only his opening statement, is that the quid pro quo will be you will get the money if and when you confirm that you will reopen the investigation into Burisma and Hunter Biden. They got the money, and I'm not sure if they ever made that announcement, in which case, where was the quid pro quo? I am asking this as a question and not making it as a statement. This is the question that is going to determine whether or not this was in fact a quid pro quo. If the monies were in fact released in the absence of a confirmation that they would reopen the investigation, was there even a quid pro quo? And in which case, is it going to be another moving target to the effect that, okay, maybe there wasn't a quid pro quo, but there was an attempt at a quid pro quo? We'll see. Moving on.
Number 3, this was never about corruption. It was about getting dirt on Joe Biden and his son. This arrangement is problematic because it essentially means that the President of the United States is subverting the national interest for his own personal interest.
This is a statement that I hear people repeating over and over again, and I don't think people appreciate that this statement itself is infused with political bias. You have people on the quid pro quo side saying that this had nothing to do with national interest, this had to do with Trump's personal interest. Legal Eagle says as much in the same video. But a lot of people are going to say that that itself is a very partisan way of viewing the situation. Why would investigating corruption only be in Trump's personal interest and not the national interest just because it involves a potential political rival? People are going to say that at this point Joe Biden is only a hypothetical political rival and that this doesn't even concern him, it concerns his son. Those people are going to question why it's no longer a question of national interest just because it happens to potentially involve a political adversary to the President of the United States. But it seems to me that Legal Eagle is creating or at least propagating this false dichotomy, that it is either in the national interest or it is in Trump's personal interest, as though the two can't overlap to some extent. But let's do what I think Legal Eagle ought to have done and frame it in non-political discourse. Even if we go by the quid pro quo angle, the government was withholding military aid, the government was asking the Ukraine to look into corruption that might have involved Joe Biden's son, and the government ultimately released the aid. The very idea of framing looking into corruption as being in Trump's personal interest and not of national interest is itself a spin on the facts. It was when they were investigating the president himself, and it ought to be when they are investigating anybody else as well. And the investigation into Burisma was closed in 2016, but it never actually exonerated Burisma. See what I did there?
But strong-arming a sovereign nation into investigating a conspiracy theory about Ukrainian computer servers and ginning up a defunct investigation into Burisma, a defunct.
All right, and here is another element of confirmation bias that swings both ways. Here Legal Eagle is saying that the investigation into Burisma was defunct. It had ended and therefore there was nothing further to look into. And I found a website that had a very detailed and seemingly accurate timeline of all of the relevant events in Burisma, Ukraine. And I did do a fact check or bias check of this website to make sure I wasn't getting duped by some totally biased website. And for what it's worth, this website which set out the timeline was deemed to be extremely accurate. The investigation into Burisma was closed by a Kiev court in 2016, but it had in fact been dormant since 2014. The funny thing here is that people are now using the fact that this investigation was closed in 2016, despite the fact that nothing had gone on in it since 2014, as evidence that it was totally invalid and improper for Trump to ask what's going on with this investigation. And this is the double swinging door of bias interpretation. Some people are going to say the investigation was closed, nothing to see here, move on, and it was improper for Trump to ask that it be reopened or reinvestigated, all the while insisting that other investigations which didn't in fact exonerate can somehow be held over someone's head to prove some sort of implied guilt. The flip side to that spin is that you're going to have some people saying the investigation, and I'm talking about the Mueller report here obviously, it was a nothing burger, tear it up and throw it away, but the investigation into Burisma that was closed in 2016, there might still be something to see there. Political bias, Rorschach test, we are going to see what we want to see in the same thing. One screen, two films. So that's that. It is a fine line between analysis and spin. Analysis is dissecting the facts, spin is telling you how to interpret them. And there's nothing inherently wrong with spin to the extent that the spin is disclosed and not disguised as analysis. All right, I've had my fun with Legal Eagle. I do like Legal Eagle, and Legal Eagle, if you ever want to do a live stream with me so that we can do this in person, I am totally game to do it anytime, any place being on the internet. But let's make it happen. I do enjoy these forced collaborations, but I would love to have a Viva Voce discussion with you so we can actually talk about this stuff as opposed to just making videos for the internet. If you like my videos, please like, share, subscribe, hit the notification bell, drop a comment in the comment section below. PayPal link up above. Support the channel with merch or whatever, but mostly share the channel, help me grow. I greatly appreciate it, and now you know your vlog. Peace out. Booyah!